Hello and welcome to the Magna Carta Prelims 2024. And this is lecture number 8 on judiciary and the legal system. Now, this particular lecture is a little intriguing. It is intriguing because the kind of questions that have been asked in the prelims exam, specifically from this particular theme, has undergone a very, very significant change. There are 3-4 important insights that come to mind. First things first, you will see a larger trend in questions around the legal system. They'll ask you things like, what does an advocate do? What is it that the advocate cannot do? What is the general system of courts in the country? So that's that. 2, there is a slight decline in the questions with respect to the Supreme Court and the High Court. You have to cover the basics, which is why I am sensing a slight pattern deviation this year, and we might see a resurgence of questions from here. And 3, from the lower courts, there has been an exceedingly low set of questions that have come. Which is why instead of calling this theme just the judiciary, I'd like to take care of it as the legal system in toto. So how are we going to go about it? We're going to study the legal system in 2 ways. 1, in a comparative manner. And 2, in a horizontal manner. Now, what does this mean? When we refer to a comparative manner, we'll compare the higher judiciary, the Supreme Court and the High Court together. We'll understand their powers, their functions, their appointments, removals, etc., etc. And when we study it horizontally, we'll study the entire ecosystem of the higher judiciary together. What are the kind of lawyers? What are the kind of procedures? What does a senior advocate do? What does an advocate on record do? And things like those. So to my mind, I think this would be a more appropriate and a more concise way of covering what is actually here. Now, in addition to this, I'd also make it very clear that a lot of the standard textbooks are not particularly very coherent and are also not very clear in terms of what they're specifically referring to, in terms of what their powers are, and so on and so forth. Now, let's understand how this works in the larger ecosystem. Let's first look at the entire ecosystem of the legal and the judicial system of India. Now, at the outset, if we just identify the stakeholders, we will understand that there are essentially 4 sets of people involved. To begin with, you've got courts, then you've got judges, then you've got lawyers, and then you've got litigants. Now, when we look at the courts, what do we understand? There are generally 4 types of courts in the country. The first set of courts are called the higher courts. Now, the High Court and higher courts are 2 different terms. A high court is a higher court, but higher courts is a larger term that we use for the Supreme Court and the High Court. Now, therefore, as the Supreme Court and the High Courts are higher courts, they are dealt with separately. They're dealt with separately also because of the fact that they are what are called constitutional courts. A constitutional court determines the constitutionality of things. It could mean validating or invalidating a law. It could mean interpreting a provision. It could mean filling a gap that exists in a law, and to any limit that you could effectively take it to. But that's primarily the purpose of the constitutional courts in the country. And that's what they effectively do. Now, then you have lower courts. We'll discuss this in a hierarchical format in a few minutes, but lower courts are generally what are called the district courts and the sub-district courts. Now, these are recruited respectively by the state governments. Most of them are generally recruited through a written entrance exam and are therefore a part of a judicial service. So you'll generally find district courts, session courts, criminal courts, so basically district courts and below. Then we have a very unique set of courts in the country. They're called tribunals. We'll discuss tribunals in a fair bit, but what basically is a tribunal? A tribunal is a specialized court for a specialized purpose, which effectively tries to solve a specific problem. What is intriguing about this specialized court is that the members of the tribunal, the judges of the tribunal, half of them are ex-judges and half of them are ex-bureaucrats. So this brings in a sort of balance and brings in the right cohesiveness that you would require to swiftly look at certain matters. They are constitutionally enabled. They're not compulsory, but they're constitutionally enabled. So you'll find them under Articles 323A and B. We'll get into them in a little more in detail. Then you also have alternate dispute resolution mechanisms. Now, alternate dispute resolution mechanisms would effectively be found with a very simple purpose. Because courts are lengthy, complex, and expensive, but justice sometimes delayed can also be justice sometimes denied. And every legal problem may not be a complex one, but is subject to complex procedures. So, which is why you would come up with specialized courts, specialized forums, specialized organizations or measures to expedite and simplify the process. For example, you'll have something called the Legal Services Authorities Act of 1987, which allows for the creation of what are called Lok Adalats. Now, these are effectively a type of alternate dispute resolution mechanisms. Similarly, you'll have a larger umbrella law, which looks at one of the methods of alternate dispute resolution, which is arbitration and conciliation. And this is done through the Arbitration Conciliation Act of 1966. Now, this act has obviously undergone tremendous changes. And this act has not been asked in the prelims exam, but surely has been asked in the mains exam. It gives you a general idea and a general set of procedures. For example, nowadays, a lot of companies have an arbitration clause, and disputes are subject to arbitration either in India or internationally. Third, you will have some law mandated processes also. For example, in most matrimonial cases in the country today, mediation is almost compulsory. So if a husband and a wife have to undergo a divorce, and before they come to a court to finally argue their sides out, the court would mandate them to finish a few mediation hearings for sure. So that's also another form of it. So arbitration, reconciliation, mediation, these are the larger forms of it. And the Lok Adalat is one of the means of achieving the same. But that's largely how the court system work. And the courts are courts because of the people who preside over them. They're called judges. So higher courts will have higher court judges. Lower courts will have lower court judges. And within the lower courts judges ecosystem, they're also a type of lower court judges. You'll have judicial magistrates who can come in different designations. So you'll have judicial magistrates, class 1, class 2, first class, chief judicial magistrate, metropolitan magistrate, and so on and so forth. Now, basically, there is a tiny bit of a difference in terms of what are the powers that they have, and we'll come to that in a bit. But you have judicial magistrates. All of these are recruited through a judicial entrance exam, whereas you have a special set of magistrates called the executive magistrates. Now, this is not necessarily the best case scenario because it violates separation of powers. And our directive principles also mandate that we must have some amount of separation of powers. But executive magistrates are essentially appointed through the civil services. And all of you will also be executive magistrates during your district tenures. So you will also have the powers to hold court, very limited powers to send people to jail, very limited powers to impose a certain quantum of fine, but you do. And if you remember the lecture on legal aid and criminal justice under Articles 20 and 22, you would remember some reference to this as well. And because India is what is called a common law system, And a common law system, as you could recall from the very first lecture, is something that we've largely inherited from England. We also have different traces of different other legal systems, but we are dominantly a common law system. And because we are dominantly a common law system, what we have is an adversarial system of practice, which means the judge will play a passive role. And in this adversarial system, it is what is argued in the court, it is what is proven in the court, is the basis of the judgment of the court. So the judge does not get to apply a mind of her own, does not get to apply any external factors, and has to decide on the merits of the case based on what is argued in front of them. They cannot participate in the investigation of facts or the discovery of truth or any of those things. What the judge can effectively do is simply argue, simply hear the arguments on both sides, and then deliver the judgment that has to be delivered. Now, so that means the lawyers are going to play a very important role. And therefore, especially in the higher judicial systems, you will have at the high courts and the Supreme Courts, you will have designated senior advocates. These are people who have been identified as senior lawyers, more experienced lawyers based on their skill, based on their ability. We'll speak about the details of this in the forthcoming minutes, but they are designated lawyers. Now, an advocate is anybody who is practicing in a court of law, governed by the Advocates Act of 1961. And especially in the Supreme Court, you have what are called advocates on record. So we'll again speak about them as well. At the end of the day, a court is about solving disputes. That means there are going to be people who have disputes. They're called litigants. Now, sometimes cases are filed on behalf of people at large. They're filed by NGOs, they're filed by organizations who are deeply troubled by the state of affairs or the lack of a state of affairs. In that case, we also have the concept of a PIL, which is fairly popular in the Indian jurisprudence. And sometimes the court can also take actions necessary to make justice right. Now, this could come from inherent powers of the court. It could also come from something called contempt of court. So the general idea here is that you have different forms of approaching the court. Sometimes you don't even have to approach a court. The court takes up the case on their own. That's called suo motu, on its own. Sometimes there's a larger issue that has been filed before the court. That's what is called a public interest litigation. So effectively what ends up happening is you are dealing with a very, very vibrant, a very multi-layered, a very complex, very internally administered judicial system. And this internally administered judicial system would effectively have two very important, you'd call, goals. We've got to be independent and we've got to be integrated. It is the independence of judiciary which has also been recognized as one of the elements of the doctrine of basic structure. It is excruciatingly important because it has an impact on some other foundational principles. For example, if you wish to uphold the rule of law in our country, you have to have an independent judiciary for multiple reasons. If you just simply look at the pillars of rule of law, they are the absence of arbitrary power, it is about equality before law, and it is about predominance of legal spirit. You cannot achieve either of these three things if the judiciary is not impartial. For example, if you are judging the arbitrariness in a governmental action and the judiciary is not independent, then there's going to be a bias. Same way, if you are judging the basis of the classification of something to be wrong or the objective to be little off for which you have made such classification, then the final outcome could be off. And what is the point of a right without an enforcement mechanism? That enforcement mechanism, by simple separation of powers, would fall under the ambit of the judiciary. And therefore, for you to uphold a citizen's right in our country, you have to have an impartial judiciary. Two, all of this will ultimately lead to judicial review, which is the review of both legislative and executive action. Now, both legislative and executive action cannot happen until you have sufficient judicial review. And judicial review with integrity can only happen if there is what is called independent judiciary. Three, you will also notice something as simple as federalism, where you have a central government and a state government. So there is going to be a point of repugnancy. There is going to be a point of conflict. There is going to be a point of encroachment into each other's spaces. To be able to impartially determine the difference between them, you would effectively require what is called independence of judiciary. And fourthly, to effectively perform good checks and balances, which is an outcome of separation of powers, you would also require independence of judiciary. So, independence of judiciary is vital in achieving some of the most important constitutional objectives. And therefore, in order to uphold the larger principles of constitutionalism, I would certainly say that independence of judiciary is fairly important. Now, having said that, we also got to be integrated. Now, how do we have to be integrated and what is the process of it? Let's understand it by first understanding the hierarchy and the structure of the Indian judicial system. So, the structure of the Indian judicial system is a fairly complex one. When we understand this, we have the Supreme Court as the apex court of the country. Now, the Supreme Court technically has its bench in Delhi, but it can have multiple benches across the country. It does not necessarily just have to be in Delhi. You can make the necessary changes if you have to, but there should be a Supreme Court, that is for certain. Below the Supreme Court, at the level of the states, you have high courts. Now, the high courts are, and this is where one must understand this very clearly, the high courts are not inferior courts to the Supreme Court. The high courts are, in fact, fully functional, in a manner of speaking, autonomous courts. Except for center-state disputes, the Supreme Court and the High Courts have almost identical powers. They can almost do the same thing. So maybe the exception is a center-state dispute or a curative petition or maybe a review petition, just a few things here or there. But in terms of hearing the types of cases, except for center-state dispute cases, every case that the Supreme Court can hear, the High Court can hear too. The rare cases such as a presidential or a vice presidential election does not really count. When we look at the ordinary litigant, when we look at the ordinary cases, the Supreme Court and the High Court tremendously have equivalent powers, which is why we never call the High Court as an inferior court, which is also when we studied Article 32, we were very categorical about it, that a writ cannot be issued by the Supreme Court to the High Court or by the High Court to the Supreme Court. It's because they're not inferior courts. Now, yes, every state should have a high court, but that does not necessarily mean that every state must have a high court. Sometimes because of geographical reasons, infrastructural reasons, logistical reasons, what would generally happen is that you may not have one high court for a smaller state. So you'll have one high court maybe in the Northeast for covering several states of the Northeast. So therefore, there is no compulsion whatsoever for every state to have a high court of their own. That's number one. Number two, you could therefore have adjoining high courts, which means you can have one high court for multiple states. You can have one high court for a state and a union territory. That's also permitted. And sometimes the opposite is also true, which effectively means that what if the state is so huge, you may need to have multiple branches of a high court. Say the case of UP, where the principal bench of the High Court is at Allahabad. And yes, it's still called Allahabad and not Prayagraj. And the additional bench is at Lucknow. And that's perfectly possible. So that's largely how we understand Supreme Court and High Courts. Now, what is interesting about them is, as I was telling you before, both of them are effectively what are called parliamentary. constitutional courts. Now, because they are constitutional courts, they would be performing a very vital function of judicial review. And not only this, the higher courts in the country would also be what are called courts of record. And both of these concepts are interrelated. They, because they're courts of record, they can perform judicial review. Because they can perform judicial review, they've got to be courts of record. This also means that they can revise their own judgments. And at the same time, they're also courts of contempt, which means they have the powers to punish for their contempt. Now, the Supreme Court can punish for the contempt of the Supreme Court. The High Court can punish for the contempt of the High Court, and other courts which are under the administrative supervision of the High Court, basically the lower courts in a state. So, three vital concepts, which is judicial review, court of record, and contempt of court powers, are strictly reserved for the higher courts because they are constitutional courts. So that's something that we've got to keep in mind. Now, these are collectively, as I told you, what are called higher judiciary. Now, both of them are, of course, appointed through a process which is called the collegium process, and we'll speak a little bit about it in some time. Below the high courts, within the territory of a state, you would have what are called district courts. Now, district courts or sub-district courts would come in many shapes and sizes. It'll all depend on the nature of the state, the resources, the infrastructure, the human resources, and so on and so forth. So we generally call them district and sub-district courts. But what you would generally see is that there is a civil side and there is a criminal side. In smaller areas, it'll be dealt with one judge. In bigger areas, you'll have separate judges, and so on and so forth. But the basic idea here is that on the civil side, you'll have a district judge, an additional district judge, a civil judge senior division, a civil judge junior division. On the criminal side, you'll have a sessions judge, an additional sessions judge, a judicial magistrate class 1, a chief and an additional judicial magistrate. You'll have judicial magistrates class 2. Now, the key part is lower judicial officers can fine less and can sentence less. So that means the powers of the district court judge to issue a sentence of imprisonment or a sentence or a fine would be higher than that of a judicial magistrate class 1. This also means the second thing. If the minimum punishment of a crime, let's say, is 5 years, then a judicial magistrate class 2 cannot hear that because the minimum punishment is beyond what the maximum punishment is that the judicial magistrate class 2 can hear. So, of course, you'll have those permutations and combinations. Now, because this is so varied from state to state, one does not really have to worry about district and sub-district courts as such. But yes, they're generally collectively called what are called lower judicial systems. Then you also have something very new and very nuanced in their own right. These are called gram nyayalayas. Now, gram nyayalayas will also hear both civil and criminal matters, but the difference is that the nature of the matters is going to be fairly minor. It's not going to be as serious. For example, a gram nyayalaya cannot hear a murder case. That's absolutely the case. But the idea is that these are to effectively create accessible sources of justice. The primary problem that the gram nyayalaya is trying to solve is the access to justice problem. So the gram nyayalaya was created through the Gram Nyayalayas Act of 2008, largely looks into civil and criminal cases, but of a very minor nature. And these four courts, the Supreme Court, the High Court, the district courts, and the Gram Nyayalayas, are effectively the formal official judicial system. And when we say we're integrated, it means a case from the Gram Nyayalayas technically on appeal can go to the highest court. The judgments of the Supreme Court are binding pan-India. The judgments of the high courts are binding pan-state. The high courts can also supervise the lower courts and so on and so forth. And that's generally how it works. Interestingly, a part of this integrated system is also what is called a tribunal. As I was telling you before, tribunals come in two forms. They're either under Article 323A or they're under Article 323B. Under Article 323A, you can create what is called an administrative tribunal. Now, because you're creating a body that will perform a quasi-judicial function, go back to rule of law and democratic mandate. So therefore, it can only be created by the parliament through a law. You can have one tribunal at the center and you can have one for the state. So, for example, you are a central government officer. For example, you are in the IRS and you have a posting problem, promotion problem. You will generally file a case at the Central Administrative Tribunal. State government officers would file it at the State Administrative Tribunal. All India service officers, whether it's the IAS, the IPS, or the Forest Service, a lot of them generally have cases to do with cadre transfers or batch empanelments or some form of administrative hiccup. They would also come to the Central Administrative Tribunal because the All India service has been recruited by the central government. Yes, you're working for the state government, but you've been recruited centrally. So the Central Administrative Tribunal will therefore entertain All India services and central services, and the State Administrative Tribunal will hear state services. Now, Article 323B allows for tribunals to be created for any other reason. Now, this means you can have a national tribunal and a state tribunal both. So, both the parliament and the state legislatures, by law, can create respective tribunals. And this could therefore be done in a hierarchical manner. But again, you have to create a law. Now, what is very interesting to note here is that whenever these tribunals are created, the constitutional provisions with respect to these tribunals are just enabling in nature. This basically means that under no circumstances is it compulsory for you to have created that kind of a tribunal. Should you have created it? Sure. But do you necessarily have to create them? Absolutely not necessary at all. Which is why you will see that all tribunals are necessarily established by an act, and all tribunals are created because the state wants them to be created. Otherwise, there is absolutely no compulsion whatsoever. And depending on the nature of the tribunal, depending on the status of the tribunal, sometimes you have an appellate tribunal also. So depending on the nature, depending on the act, some cases will directly go to the Supreme Court, some cases will go to the High Court. Now, depends again on the nature. So generally appellate tribunals or some very specialized tribunals, their cases are generally heard directly in the Supreme Court. So for example, on appeal from the Central Administrative Tribunal, which is because of the Administrative Tribunal Act of 1985, you can go to the Supreme Court directly. Similarly, you have a Securities Appellate Tribunal, which is established under the SEBI Act of 1992. So you could therefore go to the Supreme Court directly. You would have something called the Company Law Appellate Tribunal, which again very recently was not functional. You could directly go to the Supreme Court because the Companies Act allowed for this to effectively happen. When you look at the Income Tax Tribunal, now the Income Tax Appellate Tribunal, now there's the word appellate, but that does not necessarily mean the Supreme Court, because the first authority is the income tax officer themselves. So from the Income Tax Appellate Tribunal, which is established under the Income Tax Act of 1961, you could go to the High Court. Industrial Tribunal, you could have gone to the High Court. Customs, Excise and Service Tax Tribunal, now not particularly very functional. You could go on appeal to the High Court. So every tribunal has its own means, every tribunal has its own methods of going about it. But yes, you do have different tribunals. Do specific tribunals get asked? Not really. We've had one question from the National Green Tribunal, and the act that governs the National Green Tribunal is the NGT Act of 2010. And cases on appeal from the NGT go to the Supreme Court. Cases on appeal from the Armed Forces Tribunal also There's an Armed Forces Tribunal Act of 2007. Cases would effectively go to the Supreme Court as well. But again, there's no long and short form of it. There's also no need to memorize these things as well. The idea is that there are tribunals which are created by the law, and therefore, when they're created by the law, you would be able to uh, execute them the way you should have. So that's generally the idea. That's generally the context behind it, right? Now, having said that, once we've figured this part out, once we've understood this, we are now able to understand that there is a direct single layer integration, and there's also an integration of the tribunals. But that does not mean every court is a part of the integrated system, in the sense that we have something called the Lok Adalats. Now, the Lok Adalats are primarily there for alternate dispute resolution reasons. Now, Lok Adalats can only hear civil matters. There has been a PYQ from here as well. And the fact that they can only hear civil matters is more than enough. And they have been established under the Legal Services Authorities Act of 1987. I've kept 2 pages blank at the end of this lecture to give you a little more details on Lok Adalats and Gram Nyayalays, just to cover our bases, but it's not particularly to be very, very worried about. So what happens with Lok Adalats is either people voluntarily will come here, or cases which have reached here but are not significant enough and could be handled in a far more swift manner without really interpreting or applying the law without any complication, could be referred to what are called the Lok Adalat. So that's also possible. So cases from district and sub-district courts could be referred to what are called Lok Adalats. So this is generally the system. And again, the basic problem that you're trying to solve with the judicial system in India is that it's too slow, it's too complex, and it's too expensive, which is exactly why sometimes to solve the slow problem, you've created what are called fast track courts. Now, fast track courts become important simply because your fast track courts give you a dedicated time limit under which you have to solve that legal problem. So you have fast track courts, for example, for women and children. You have also special courts for MPs and MLAs. These courts are to dedicatedly solve criminal issues concerning MPs and MLAs. Sometimes you'll have the family courts also under the Family Courts Act of 1984, which will specifically be looking at matrimonial disputes because there are too many and too much of these. So these are generally in and around on parallel to the district courts. So if the case comes up here, it either gets transferred here, and on appeal, you would generally come here. Now, this is a matter of internal legal procedure, so you don't have to worry too much about it. What you should definitely know is that there are fast track courts, there are MP MLA courts, and there are also things like family courts. It is important for you to know what fast track courts are, to be very honest, simply because fast track courts make you understand the need for solving a specific case for a specific time. So generally what happens is the setting up of these fast track courts and its functioning lies within the domain of the state governments. And this is generally done in consultation with the respective high courts. In fact, if I remember correctly, the 14th Finance Commission had recommended the setting up of about 1,800 fast-track courts during 2015 to 2020, dealing with serious cases of heinous crime, civil cases relating to women, children, senior citizens, so on and so forth. And generally, you would want to do this for a specific type of crime. Similarly, you have a special set of courts for MPs and MLAs. Now, why would you want to do this? This is because the Supreme Court had very clearly issued a direction. I think it was sometime in 2017, that the union government should facilitate the setting up of about 10 or 12 special courts in states for the expeditious trial of criminal cases involving MPs and MLAs. And therefore, 12 such courts were set up. to my best understanding, I think 10 courts are functional about 9 states. And the performance of these special courts is generally, for MPs and MLAs, is generally monitored by the Supreme Court of India. And these special courts are very much a part of the formal integrated legal system, and they're there for a specific cause, for a specific purpose. And that's generally what the structure of the system is. Now that we understand the structure of the system in its entirety, let's now get into the higher judiciary. Let's look at the overall review of the higher judiciary in terms of how it functions, what is it supposed to do, and so on and so forth. Now, when we refer to the higher judiciary, we are generally referring to the Supreme Court and the High Court. The first things first, we've got to understand the governing provisions, and then we'll therefore understand the insights and generally what is called the structure of it all. So primarily, the story starts from the Constitution of India. Both in Part 5 and Part 6, you have relevant commensurate provisions for the Supreme Court and the High Court. And these are the general overarching structural provisions which tell you how a judge is to be appointed, to be removed, what are the general procedures that they have to follow, what is the general jurisdiction that the courts would have, and so on and so forth. You will generally find a basic structure of the higher judiciary sort of clearly articulated in the Constitution itself. Now, this has not been enough, and we've seen a fair degree of evolution on this particular point. So, on the specific issue of appointments, transfers, and removals, you will see that the third judge's case was that key case because of which the Supreme Court had outlined a certain method to which Supreme Court and High Court judges could be appointed and could be transferred. Now, transfer is generally for the High Court judges. Supreme Court judges aren't transferred. And based on the directions of the Supreme Court in the third judge's case, you have two memorandums of procedure that have been created. These memorandums of procedure are to basically be in line with what the Supreme Court has said. So the memorandum of procedure, there's a separate memorandum of procedure for Supreme Court appointments. There's a separate memorandum of procedure for High Court appointments. Now, this has been done to implement the guidelines or the instructions that have been given to us in the third judge's case. Apart from this, you also have the Judges Inquiry Act of 1968, which effectively gives you a detailed procedure supporting the constitutional provisions with respect to the removal of Supreme Court judges or even High Court judges. And you have the Judges Protection Act of 1985, which gives you similar protection that the president and the governor get in terms of immunity. What it basically says, and it's not the same degree of immunity, it's not the same depth of immunity, I'll be very clear on that. But what it generally means is that the Supreme Court and the High Court judges will not be charged with anything done in the course of their duty as a Supreme Court judge or a High Court judge. So therefore, this kind of an immunity is given to them under the Judges Protection Act of 1985. Now, apart from this, beyond the appointments, transfers, and removals of Supreme Court judges, you would also have something called, the conditions of service. Now, with respect to the conditions of service, you have a few set of laws under which a few set of rules have been made. Now, see what's written and see what's missing. So you've got the Supreme Court Judges Number of Judges Act of 1956, because the Constitution permits the Parliament to determine the strength of the Supreme Court judges, checks and balances. And you have the Supreme Court Judges Salaries and Conditions of Service Act of 1958, supplemented with a certain amount of rules. This determines the allowances and all of those things. Of course, for security of tenure and for independence of judiciary purposes, their salaries or emoluments cannot be decreased to their disadvantage, like in the case of the president or even the governor for that matter, but you still have a law regulating their salaries. Similarly, you have a High Court Judges Salaries and Conditions of Service Act of 1954, which is again a parliamentary law. So there's a parliamentary law governing what is called the salaries and the conditions of the High Court judges, supplemented by the rules. We also have a dedicated law called the Contempt of Courts Act, which deals with civil contempt and criminal contempt. What is a contempt has not been defined, but broadly, a civil contempt is a contempt which is effectively for disobeying a court order, whereas a criminal contempt is a contempt where you are disrespecting the judge or the institution of the court. Now, there has been a PYQ from here also, and a very questionable PYQ in the way that it was framed. If I remember the question correctly, it was the Supreme Court and the High Courts have similar powers with respect to punishment for contempt. Well, technically, that was the question, and it was a very intriguing question. When I give you the PYQ lectures for this, you be able to understand how the question could have swung both ways. But both courts have similar powers in terms of what they can do to punish. And also, contempt of courts is, in a way, the birthplace of suo motu powers, because you are taking action for disobedience or disrespect against you, which is civil or criminal in nature. Now, the civil, as I told you, is nothing but disobeying a court order, and criminal contempt is disrespecting the judge or the court. Apart from this, the courts are also empowered to make regulations with respect to their procedures. Now, these would be subject to presidential and parliamentary approval, but you can make your set of rules. So, for example, there are the Supreme Court rules of 2013, which will tell you the exact guidelines, the exact procedure under which a PIL can be filed. Now, those Supreme Court rules have a statutory effect. They have to be followed. But the Supreme Court has drafted the rules for the Supreme Court, and that's perfectly permissible. So, what are the basic insights that we derive out of here? The insights that we derive out of here is that there is a very clear-cut hint of rule number 2, which is center stronger than the states. This is one of the golden rules that we had studied. And our key insights are that as far as the Supreme Court is concerned, the strength is determined by the parliament. And today we are on full sanction strength, which is, of course, 34. And the powers and the service conditions of the Supreme Court are also determined by the parliament. So basically, the parliament can decide the strength, the powers, the functions, everything about the Supreme Court if they want to. Whereas the High Court is concerned, the strength of the High Court is actually determined by the president. Of course, we know that the president really has no independent powers of their own. The president would be functioning on the advice of the Council of Ministers. But the key point to note is that you don't need to make a law to determine the strength of that particular High Court. Now, very interestingly, although not relevant for the prelims exam, we do have a law called the Delhi High Courts Act. Now, this effectively ensures certain salary considerations of Delhi High Court judges, given the fact that the Delhi High Court is in a very peculiar position, because there are certain subjects within Delhi which are governed by the center, and there are certain subjects, a majority of them are left with the state government. So police, land, and law and order are with the center effectively, and the rest of the subjects are with the state. And therefore, there is always a unique nature with Delhi because the central government is also physically housed in Delhi. So, with that exception aside, the powers and the service conditions of the High Court are determined by the parliament or the state legislature if need be. Now, this itself becomes a little bit of a gray area, and therefore the chances of it being asked in the exam are definitely not very, very high. Now, when we look at the organizational structure of or the composition of these courts with a little more detail, horizontally and comparatively, the Supreme Court is headed by the Chief Justice of India. You have Supreme Court judges. Now, there's also somebody called the Registrar of the Supreme Court, who, by the way, is also a judge, but is not performing a judicial function. And generally, what happens is, and this is just convention, just to garner some interest, the Registrar of the Supreme Court either ends up becoming a judge or of the Supreme Court, or definitely ends up becoming a judge of one of the high courts in the country. So the registrar is also a judge. It's just that the judge is not performing a judicial function. It's like how a doctor is the dean of a medical hospital. So you are teaching, you're administering, but you're not practicing medicine. The same logic. Now, the Supreme Court also has a special set of lawyers called advocates on record. You also have senior advocates and advocates. What the difference is, we will do the same in just a while. But you've got essentially three classes of lawyers. You've got advocates on record, you've got senior advocates, and you've got advocates. Now, fairly similar are the high courts. You've got a chief justice of the high court. You've got high court judges. You've got the registrar of the high court, again, who is a judge not performing a judicial function. You've got designated senior advocates and you've got advocates. What you do not have are advocates on record when it comes to the high court. Now, it's very important for us to understand the relationship between the Chief Justice of India and the Supreme Court judges and the Chief Justice of the concerned High Court and High Court judges. Make no mistake in understanding this, that they are not inferior to each other. As the Chief Justice of India and as the Chief Justice of the High Court, you are holding a higher administrative position. There is no appellate power, there is no superior judicial power of any kind. You are effectively, as the Chief Justice of the Supreme Court and the High Court, you are effectively you're effectively what is called the master of the roster. Now, as the master of roster, what effectively it means is that you are deciding which case will go under what judge or in what courtroom and so on and so forth. That is pretty much it. There's nothing really more to that. But that's largely what the governing provisions are. This is the larger ecosystem. Now that we understand this, we should now take a magnifying glass and get into this with greater degree of, let's say, comparison. So let's get down to it. Okay. So we've got the Supreme Court judges and we've got High Court judges. Let's quickly look at how appointments are done. Now, be absolutely clear on this, that as far as the Constitution is concerned, the Supreme Court and the High Court judges are appointed by the President after adequate consultation with Supreme Court or High Court judges. Now, what is the kind of interaction? How are the interactions executed? All of those things are then dealt with the third judge's case. But the Constitution doesn't get into the composition of the collegium, doesn't get into how many judges are going to be there. That is all taken care of by the third judge's case. And then the memorandum of procedure. The Constitution starts here and the Constitution ends here. This has been interpreted in the third judge's case, finally, through a collegium process. So with Supreme Court judges, the collegium generally is the Chief Justice of India and 4 senior Supreme Court judges. If there's a seniority clash, then you can increase the number of judges. It does not matter. It is an internal process, which is why they've never asked a prelims question from here, because it is very circumstantial. Anyway, so the Supreme Court Collegium consists of the Chief Justice of India and 4 senior Supreme Court judges. Now, they generally function on the principle of consensus, which means everybody has to agree on the same name before you are suggesting the name finally to the President. As far as the Chief Justice is concerned, you generally follow the seniority principle, and it's that simple. See, the Chief Justice of India is the highest ranking judge of the Supreme Court, and Article 124, Clause 1, if I remember correctly, establishes the Supreme Court of India. And what is important to know is that Article 124, Clause 1 very clearly says that you must have a Chief Justice of India. And which is why the Chief Justice is also often called the first amongst equals. Because what generally happens is when a case is admitted to the Supreme Court, it's the Chief Justice of India who decides which bench should be hearing this case, how many judges should be hearing this case, and who the judges are going to be. And this, if the CGI is there, the CGI will therefore lead the collegium, which is responsible for recommending the judges for further appointments to both the Supreme Court and the High Courts. Now, under Article 124(2), the President is therefore given the power to appoint the Supreme Court judges, including the CGI. Now, the memorandum of procedures is very clear on this. This is again after insight from the third judge's case, that the CGI should be the senior most judge of the Supreme Court. Now, the actual procedure is this, that the Union Minister for Law and Justice will write to the outgoing CGI, will ask the outgoing CGI to recommend a successor. After receiving the recommendation, the law minister would forward it to the prime minister, who will then accordingly advise the president. So ultimately, it's the president who will decide whether to approve the recommended appointment or not. And because there's a seniority principle, so generally there are no issues of this. But yes, it is the senior most judge. Now, similarly, with High Court judges, you have a collegium. The collegium for High Court judges is smaller. The CGI is going to be a part of the collegium to decide Supreme High Court judges, and two senior Supreme Court judges are also going to be a part of the collegium. So the minimum requirement for a collegium is smaller. The collegium also works on a consensus basis. Now, of course, when you are appointing the Chief Justice of the High Court, it's generally done on a seniority basis, but you can also consult the governor, which is effectively consulting the concerned chief ministers. And as far as the other judges are concerned, you will also consult the Chief Justice of the High Court while appointing other judges to the High Court. The chances of this again being asked in the prelims is next to zero, because these are internal procedures, contrary to the drama around it. But yes, this is how it's done. All of this is mentioned in the memorandum of procedure. If you really want to read more about it, you can go to the Law Ministry's website and you would find memorandum of procedures under administration of justice on the website there itself. Now, the qualifications are very interesting because you will find they have almost exactly similar qualifications. Now, for Supreme Court judges, you've got to be a citizen. It's the same as for High Court judges, without any exception whatsoever. And you can be a citizen in any manner whatsoever. And then you've got to be a High Court judge for at least 5 years, which means to be a Supreme Court judge, you've got to be practicing in any High Court for 5 years. It does not necessarily have to be 5 years back to back. It does not have to be in a specific High Court. It could be a combination of High Courts, but you've got to have 5 years of practice recorded. With High Court judges, it's about 10 years. So, and this is 10 years for a judicial office, because obviously you can't be a High Court judge and have a qualification to be a High Court judge to become a High Court judge. So any judicial office, which effectively means a district judge, a sub-district judge, and so on and so forth, but for 10 years. And that's effectively the primary difference. Then what is common to both of them is that you can be a High Court lawyer for 10 years and you're eligible to be considered by the collegium. In addition to this, what is also slightly different is no distinguished jurist as per the precedent. So to be appointed as a Supreme Court judge, one of the other qualifications that you can have is you could also be a distinguished jurist in the eyes of the president, which is effectively the Council of Ministers. Now, this is obviously not particularly mentioned in the case of the High Courts. Now, what is a distinguished jurist is not defined anywhere, and how do you become a distinguished jurist is not defined anywhere. But it's generally understood that you are somebody who has great knowledge of the law. And while your retirement ages for the Supreme Court is 65 and the High Court is 62, and this is to incentivize High Court judges to also consider Supreme Court positions, but there's absolutely no minimum age whatsoever for you to be considered a High Court judge. Now, the provisions which are important is how are you securing the independence of the judiciary? See, the salaries and the pensions of the Supreme Court judges are charged to the Consolidated Fund of India. The salary of the High Court judges are charged to the Consolidated Fund of the states. But the salary of the Delhi High Court judges are also charged to the Consolidated Fund of India. And the pension of the High Court judges are charged to the Consolidated Fund of India, which basically means the salaries and pensions of Supreme Court judges is charged to the Consolidated Fund of India. And the pension of High Court judges is also charged to the Consolidated Fund of India. This is also because once you've retired from the High Court, from the position of a High Court judge, you cannot be practicing in the same High Court at any given point of time. And that's largely because you would have a conflict of interest. And that's also why you will generally see a difference in the way the High Court judges are positioned versus the way the Supreme Court judges are positioned. And as I said before, they have the powers to make their own rules. Now, as far as the oath is concerned, a procedural regularity, the oath to the Supreme Court judges is delivered by the President, and the oath to the High Court judges is delivered by the Governor for obviously logistical reasons. Though the appointment to the Supreme Court and the High Court judges is done by the President, but the oath is technically given by the Governor in the case of a High Court judge. So this is generally how you would see the structure and the composition of the High Court judges and the Supreme Court judges at work. Now let's understand some vacancy provisions. Now, or removal, or the position is empty. As far as vacancies is concerned, both the Supreme Court and the High Court judges have exactly the same process. There's no difference whatsoever. So what generally ends up happening here is that you will have a vacancy because of resignation. Now, the key thing to note is the doctrine of who appoints. Both Supreme Court and High Court judges are appointed by the President, and they are both removed by the Parliament, and the final order is still issued by the President after the Parliament has done their job. The oath to the High Court could be given by the Governor, but when it comes to resignation, both Supreme Court and High Court judges will resign to the President of India. And that's the primary understanding. Now, as far as removal is concerned, the Constitution refers to two things. One, the grounds, proven misbehavior or incapacity, and both of them are not defined anywhere. What is proven misbehavior and what is incapacity? Like office of profit, like judicial review, like federalism, not defined anywhere at all. The authority to do this is the Parliament of India. And the Parliament, therefore, gets to do this by passing special majority 2, which is more than half of the total strength and more than 2/3 of present and voting. Now, both the houses, the Lok Sabha and the Rajya Sabha, have equal powers, and both of them will sit separately and vote on this. Now, this is all that the Constitution says. But then a detailed procedure is highlighted under the Judges Inquiry Act of 1968. Now, the Judges Inquiry Act of 1968 gives you a very basic procedure. You cannot randomly start removal procedures. What you would do is, first you will have a motion. If you remember our lecture on legislatures, I told you that a motion is the building block. It is where all parliamentary proceedings have to happen. So you'll have to first pass a motion to remove a Supreme Court or a High Court judge. Now, this motion could be introduced in any house. It has to be supported by, at least if it's in the Lok Sabha, it has to be supported by 100 Lok Sabha members. If it is in the Rajya Sabha, it has to be supported by 50 Rajya Sabha members. And the presiding officer may accept or may reject the motion even after it's passed, which is a unique point of view. And once that is done, then a 3-member committee is appointed. This 3-member committee is appointed by the presiding officer. This committee would include the Chief Justice or a senior judge of the Supreme Court, the Chief Justice of the High Court or a senior judge of the High Court, and a distinguished jurist. So obviously, if you are removing the Chief Justice of India, then the Chief Justice of India will not be on the committee for principles of natural justice. And then the committee will have their investigation, they will have their procedure, and they will come up with a report declaring the person is guilty or not guilty. No matter what the case might be, it is not binding on the House. And then both the houses will sit separately and pass what is called a special majority vote and remove your Supreme Court judges. The fact of the matter here is that when you're removing Supreme Court judges or you're removing High Court judges, the process is exactly the same. There is absolutely no difference in the way you are removing Supreme Court, High Court judges, which also gives you a fair bit of indication that the kind of work that they do is fairly important in terms of the powers that they have, the jurisdiction that they command, and so on and so forth. So therefore, the jurisdiction becomes extremely important. Now, once we've understood this, and because they're removed in a certain way, which is very similar, which means they would have very similar powers. And therefore, it makes appropriate sense to now understand what is called jurisdiction.